This is Dami Chidi. Let's switch gears to something you, I mean, that's your natural habitat. In your own column, some years back, you warned that Nigerian judiciary was going back to the pre or 1993 era. The 1993 collapse of the judiciary. Is the Nigerian judiciary, in 2026, is it a more captured, is it a more captured institution than the 1993 version?
I think so. Yes. The capture is obviously scaled up. I mean, of course, a lot of young people who watch this will say, what happened in 1993? And, it was slow in the making, from the onset of the Buhari administration or regime in 1984 to the time of the June 12 election. But something changed at the June 12 election. The use of the judiciary to both truncate democratic process and also to establish legitimacy of regimes was established in 1993.
Through the courts.
Through the courts, okay? Through the exercise of judicial powers in the ordinary adjudication of cases. So you had Justice Saleh, in the ABN case, truncate an administration or truncate a process of establishing the mandate of Chief Abiola. You had Justice Dolapo Akinsanya then truncate the legitimacy of the ING, the Shoneko administration. Yeah. And through that, they then laid the foundations, first for the nullification through Dahiru Saleh, and then, what's her name?
Justice Beme,
right?
Yeah.
And then, subsequently, the foundations for the Abacha regime. Those two things fundamentally altered the nature of the judicial enterprise in Nigeria. And so when we're here now, and it's not, the judges took notice that all of a sudden they had power and they had relevance. But you know what that means also? We don't matter. You and I don't matter. As citizens, I would never tell anybody, don't go and register to vote. Don't collect a PVC, because that's an entitlement. And there is hope in the idea of carrying a PVC, of being registered to vote. So I could never possibly encourage anybody not to register to vote. But I'm also realistic. Voters don't decide elections in Nigeria. Citizens don't decide elections in Nigeria. Judges do. The judges decide elections in deals, backroom deals with politicians. That means the politicians are now self-interested in who becomes a judge. Ordinarily, the process is such that the politicians play a backroom role. The judges should control it, the profession should control it, and come up with credible candidates. Actually, in the Nigerian system, the opposite of credible is incredible. So we now are coming up with these truly incredible candidates or nominees as judges. And the worse or more venal a person is, the more you have over them to be able to control them or dictate to them, the more amenable and the more likely they are to become judges. So the idea that someone is independent-minded, professional, excellent, possessed of integrity, intelligent, with proper qualifications, is not a right qualification to become a judge. The opposite of those things will make it easier for you to become a judge. That is where we are. And of course, there is what I call the genitalization of the Nigerian judiciary, which is the fact that the pattern, the pathology that manifests itself these days, and what is it that, to become a judge, or to become a successful politician, you need to have a judge in your bedroom. If it is not your bedroom of marriage, it's your bedroom with a side chick, right? And if you don't have that, you're not likely to do it. So you need to have the kind of skin you need to have in the game is skin from a particular part of the body of the opposite sex with whom you have genital contact and who can enable you to access certain kinds of decisions that are made at the highest levels of the judicial system. So you now have wives and concubines and children, all of them making up a majority of the new appointments that are going into the judiciary. And so, these days, when you see a list of judicial appointments, particularly at the threshold level of the High Court, Federal High Court, FCT High Court in particular, and most state high courts. You give me the list. I'll tell you who produced. This one is from that family. This one is produced by that person. This one is the allocation of that person. That's not how the judiciary was supposed to function.
So the culture that you and I grew up in the 70s, 80s, where judges were appointed purely on merit,
no longer exists.
You mean that we don't have that in Nigeria anymore?
It no longer exists. And no, I'm not, of course, saying that.
And you talked about Iroele in one of the
I talked about Iroele. I abused him every day.
Exactly.
I woke up every day to abuse him. I'm happy to say that I did. Because Iroele was a total, complete, something I cannot say unsaid. And, I'm glad the people who have succeeded him are seeing what the records. It's just that, people have got to try and preserve a modicum of respectability for the institution. But I'm glad, as I said, that the people who succeeded him are seeing the mess he created. It's unspeakable.
He put his daughter, son-in-law, brother or cousin or something. I mean, you said
his brother as accountant, in charge of accounts, his son as a judge, his daughter-in-law as a judge, and so many other things I can't even describe here. But yeah, and of course, in the process of doing that, it's not as if the people who have to do the appointments, because the appointment has got to be done by the executive, and many of them have got to go through parliamentary oversight or consent. So the people who are also doing that have to grant him that so that they can also get their own allocations. So you have, in every appointment round now, you can see that person is that person's child. That, in the penultimate round, or was it the last round at the FCT High Court, 8 of the 12 were children of judges, directly. You could say there's a particular judge, there's a particular family that has 3 of them from Ekiti. So one is a judge of the Ekiti High Court, another is a judge in, I believe, the High Court here in the FCT, and the third is in the Federal High Court. Siblings. Their father was a judge, right? So, there is this judicial gene running in the veins of this fantastic family. All of them are produced to be judges, right? It doesn't make sense. Of course, there is not like a judicial gene that exists. It's all a corrupt system of capture, right? And it's the same thing, you see how these things work. So ahead of the last elections in 2022, while Tanko Muhammad, late, was still Chief Justice, one of his sons became a nominee of APC to go to one chamber of the National Assembly. Another of his sons became a nominee of the PDP to go to one chamber of the National Assembly. Where are they now? When Zainab Bukachua was president of the Court of Appeal, APC quickly nominated her husband to become a senator. Where is she now? Where are they? She's left the Court of Appeal, and what has happened? The husband is irrelevant. And that's the same husband who went to the Senate to celebrate how he was doing things in the bedroom with his wife to, arrange judgments on behalf of for the benefit of his colleagues, correct? Their daughter is a judge. One of the youngest judges ever appointed in our system. That was the retirement benefit. So this is the nonsense that we do. And I pity the young children, to be perfectly honest with you, because many of these children don't want to be judges. But their parents make them trophies. Because, let me be perfectly honest with you, judging is not an easy thing to do. Sitting all day, from the age of 33, 34, 35, you sit, if you do it conscientiously, it ruins your life. Okay? You sit through 7-8 hours of arguments, listening to people. You have to write, by longhand and keep writing because the system does not provide for you. And how much are you paid as a judge? In any case, not a heck of a lot of money, no matter how many millions they think it is. Or people think it is. It's actually not worth the amount of suffering you have to do as a judge, properly speaking. And you go through you start doing that from 33, 34, because your parents want you to go and take that punishment. Nobody should wish that on a person who does not want to do it, who is not intentional about doing it. And many of these young people are not intentional about doing it. The only thing is what? Papa Madi, Mama Sokwe. Right? So all these Mama Sokwe's judges, that's how it is. Baba Sokwe's judge, that is how it is. And we've got too many of those now because there's a pipeline of political pressure and political benefit to be served. That's how we've ended up where we are.
I want to speak to the specific cases in recent memory that were so outstanding in their bizarreness, if there's any English such as, as such. Number one, Peter Lifu, Federal High Court judge in Abuja, who openly, unreservedly, challenged the authority of the appeal court in the ADC case. And then, of course, the other one in Lokoja, recently in the case of the NDC registration, say, no, I changed my mind. He had given a verdict last year that NDC should be registered, only for him to come back, and say, no, the People's Peace Movement, I can't call them party because they're not registered, association. They've come back to say, the logo that the NDC is using originally belonged to them. So he's empaneled the judge, the court again, and said, no, don't register, I deregister you, NDC. Can you speak to this?
I've written extensively on both specimens, judicial specimens that you referred to, Peter Lifu and Issa Dashin, right?
Yes, Dashin.
And I took time to look at those decisions, line by line. Yes. Now, if you take, say, Issa Dashin's case on the NDC, there's a judgment of 10th of December 2025 by which he ordered INEC to register the NDC, that's the Nigeria Democratic Congress, and in which and now if you read that judgment, it's a 24-page judgment. There are very important things he says in the judgment. And now what had happened was INEC had notified NDC on the 25th of September 2025 that they were ineligible to be registered. NDC went through the process of serving them notice and then sued to compel them, saying, we have fulfilled all the conditions, INEC does not have a discretion. Now, in its counter affidavit in the case, INEC claimed that, in its original letter of 25th of September 2025, INEC had claimed that the reason it was not going to register the party was that its logo resembled that of the APC, the All Progressives Congress, which is the ruling party. Now, when it filed its counter affidavit in the case in November last year, INEC then changed its story to say not that the logo resembled that of the APC, but that it resembled that of the Peace Movement Party, which was not a registered party. Now, in his judgment, Issa Dashin considered this issue and said that the idea that a logo, under Section 222A of the Constitution, the idea that a logo resembles that of a registered party is not a ground for denying registration. He was very explicit on page 21 of his judgment. Okay? Now, that also can only mean one thing, that the idea that a logo resembles that of an unregistered party or political association is a non-starter. He also said that this Peace Movement Party issue had not been brought to the attention of NDC, so they did not even know about it, and that it was belated and an afterthought. I'm using his words. Belated and afterthought. Those were in the judgment. Fast forward, his judgment of 26th of June. This year. He then, now, in this case, now, after the judgment, INEC complies, right? Registers NDC. Then, on the 4th of May, somebody else sues. 5th of May, somebody files a case, an application in the court. This person is not a party to the case. He's not seeking to be made a party. To the original case. To the original case. He's not seeking to be made a party to the case. He understands he is out of time, so he applies to Issa Dashin asking him to grant him permission to apply to set aside the judgment, because an extension of time within which to apply to set aside the judgment. That same application, he then says, and after granting me extension of time, I want to move to set aside the judgment. The judge does not consider the application for extension of time. There's no application to be made a party to the case. The judge just moves and sets aside his judgment. How then did he deal with the issue of logo not being a ground for setting aside? He did not deal with it. In my view, on the face of the record, that judgment is corrupt, and we have a duty to say so. The ruling of 26th of June is manifestly corrupt. And my question is, do these judges actually write the judgments for themselves? Peter Lifu, to the knowledge of anyone who has been to his court, is not well. He is recovering from what appears to have been an aneurysm. That's a stroke. He's got a partial paralysis. Ask anybody who has seen him. How does he write a 103-page judgment? I will not go beyond that. But I think it is important for us to start asking very brutal, honest questions. How is a judge who is barely able to function write a 103-page judgment? Like, seriously.
Chidi, let me ask you.
No, let me also be perfectly clear. There are very honest judges still in Nigeria. I think it is important to say that. So I'm not sitting down here saying every judge is corrupt. And that is why I do not say that. I focus on specific examples of manifest corruption on the record, because those should not happen. And when they do, they tarnish the judges who are trying to do their work properly and who are making good effort in a bad system to try to live true to their conscience, to their profession, to their judicial oath, and to the law. And we've got to continue to find ways of encouraging those people without endangering them, particularly while they are still in service in a system that does not like people who are upright.
I was going to ask you, Chidi, since this, the bizarre case of Justice Peter Lifu, who disobeyed so recklessly or so wantonly the express decision or pronouncement of the Court of Appeal that stay action on this matter till October, when we'd hear the substantive. But he hurriedly, summoned the lawyers through a WhatsApp. By WhatsApp, and then the lawyers were there told me personally that you came to, and he was just ranting. They were trying to call his attention that no.
He said on record in the judgment, nobody can arrest my judgment. He said it in the judgment.
So my question, Chidi, this one, and then because there were no sanctions, no reprimand of any sort, apart from the Court of Appeals, reprimand when they gave their stay of action judgments a couple of days afterwards, would seem to have emboldened, Issa Dashan in Lokoja. So the institutional safeguard, to reprimand, to weed out corrupt judges, to sanction them, so that to serve as a deterrence to those in the system, so they don't copy what's going on. Because to the best of my knowledge, I don't think anything has happened to Peter Lifu.
Now, the NJC appears to have, that's the National Judicial Council, appears to have developed the doctrine that judges, they can only act on judges upon a petition written by someone. In the past, the NJC used to be able to take up cases of its own motion. Now, it appears to be its doctrine, first of all, that cases can only come to them by way of a petition. Secondly, a petition is only cognizable, can only be taken by the NJC if it is accompanied and under an affidavit. So, they then render it into a process, that is very much judicial, right? So, if a petition is not accompanied by an affidavit or under an affidavit, it is formally discharged. It's not even receivable. That weeds out most of the petitions because most people do not know that that's what the rules require. Then the third doctrine they have developed is that if a matter can be dealt with on appeal, then they will not hear it. When you add up these three doctrines, it weeds out over 70% of the cases that are due to go to the NJC, right? Now, of course, the idea that a case can go on appeal is not incompatible with the existence of judicial malfeasance. But the NJC has developed this doctrine that appeals cure all things. Of course, the problem with appeals is, first of all, they take time. 2, you need money to do that. And 3, the court systems take their time to reach a judgment. Now, by the time, through all of that, if you do not recognize that there is a distinction between the administrative disciplinary track and the judicial appellate track, and you're conflating both, what you're doing is giving cover to judges who may not actually be fit for the system to continue to do damage in the system. And that's what the consequence of these 3 doctrinal pillars has become. That the judiciary is increasingly complicit institutionally at the senior levels in promoting the careers of judges who actually do not belong in the system and are giving it a bad name.
Chidi, as you sit here today, what or who is the single biggest threat to our judicial independence in Nigeria?
I couldn't. If you asked me to say, I mean, of course, there's enough responsibility to go around. I'm not going to excuse senior lawyers from responsibility. There are lots of senior lawyers doing terrible things and corrupting the system. That's a fact. And I think we've also got to own up to that reality. That said, I think the thing I took away from my time at the National Human Rights Commission, because I was the first chair of the National Human Rights Commission who had to live with a statutory framework of an independent institution. I'm not the first chair of the National Human Rights Commission, so people don't come and quote me now and say that's what I'm saying. So before me, you had Justice Nwokede, you had Justice Uchomo, and you had Justice Emmanuel Ayola. They preceded me as chairs of the National Human Rights Commission, right? But that was under a different, over 17 years. That was under a different statutory regime in which the National Human Rights Commission was, for the most part, under the Attorney General of the Federation. In 2010, the law was amended to make the commission an independent institution. And I was the first chair under the new regime after 2010. That's the point I'm trying, just so that those who watch this are clear about it. Now, the lesson I learned was independence is not donated.
It's not given.
No. You have to work for independence.
And assert it.
And assert it. Right? And working for independence is not just material. It's not just so that you have a good house, a good car, and all those things. As a matter of fact, those things can also make you lose independence because you then begin to think that is where it ends, right? As a matter of fact, as the chair of the National Human Rights Commission, I refused a car. Okay? They didn't know where I lived. And that was also for my own protection. Now, so independence is not just material, it's your salary and all of that, as useful as those may be. Independence, for the most part, number one, is psychological. It's an orientation, it's your neural wiring. Number two is your expertise. Because if you actually if you have expertise and the work you do is not speculative, it's built on evidence, people may not like you, but they cannot fault you. That's the second thing. Thirdly, independence is also an assertion. You've actually got to claim it. You've got to navigate it. And independence, when you're doing independence, people will know because you face resistance, you face pushback. Now, in that sense, therefore, the biggest threat to independence of the judiciary is the judiciary itself. It's very simple. Now, you see, I hear people say, well, we cannot blame the judges. These politicians come and... That's not true. The politicians know the judges that they go to, who they can do business with. And there are some of them who you say, why don't you go to this one? They say, that one is a madman or madwoman. No, please, just leave them alone. Let them do their thing. Because they know the honest ones. And some of those still exist. But when the politicians know that they have you in their back pocket and they can always come to you and you issue an interim injunction ex parte in their favor at midnight, that says a lot. So in that sense, therefore, it's not enough to say, well, judges are being importuned by things that they should not be importuned with, because most judges know the things that they can do and the things they cannot do. Courts are not invented in covens or grooves. Courts are created by law. What they can do are limited by whatever a court can do is invariably limited by law. Their procedure is constrained and established by law. Everything about a court is determined by law. It's therefore not possible to tell me, well, you can, judges are confused about what they... No, they're not. In that sense, therefore, it is up to the judiciary to advance the cause of independence, of their independence, or interdependence that is credible, which is probably a better way to put it. So, because they've got to exist within the infrastructure of the public institutions. But there is interdependence in that system that is credible, and there is interdependence that's not credible. So, for instance, you have the chief judge of the Federal Capital Territory removing himself from his office with his judges and going to the office of the minister of the FCT to tell the minister of the FCT, we are part of government too, and we have a duty to make government for you function. That is not credible interdependence. That is judicial corruption. This is the same country in which somebody like Emmanuel Araka, who was chief judge of Old Anambra State, was got rid of by Alison Madueke, who was military governor, because Araka refused to go and visit Alison Madueke in Alison Madueke's office. So we've had judges who have independence. J.I.C. Taylor, as chief judge of Lagos State, declined to go and stand in the rope line for General Gowon when Gowon was visiting Lagos, when Mobolaji Johnson was governor of Lagos State, because he said, I have to adjudicate cases in which the military governor and the head of state are defendants institutionally before my court, and I've got to maintain the appearance of independence. No, these days, judges wake up on Sunday, they are doing Owambe with politicians. On Monday, they are sitting in cases involving those same politicians in their own courts.
There will be no independence.
It's not just independence, but also appearance.
Absolutely.
The optics do matter.
Absolutely. Perception and all of those. You mentioned the role that senior lawyers play in all of this desecration of our judicial temple. The one that people are talking about, is the Attorney General, Lateef Fagbemi. In the case before, the ADC case, before Peter Lifu that we referenced, it was a shadowy group that brought that case.
Correct. Like ABN in 1993.
Exactly. Clubbered together, allegedly, from the office of Femi Gbajabiamila, the same Femi Gbajabiamila, Chief of Staff. Now, Attorney General Lateef Fagbemi's
Association
office,
of Former Legislators.
Exactly. The registered incorporated trustees of former legislators, He was defendant in that case. But suddenly, it became that, yes, they registered these 5 political parties. Accord, ADC, APM, a couple of others. And my question, Chidi, is, many have fingered the presidency, the ruling party, in the obvious, manifest bid to destabilize opposition political parties, PDP, SDP, ADC, Accord, NDC now. Can you speak, what would make a man such as Lateef Fagbemi, that used to have, well, maybe he still has, some level of integrity and self-respect within your profession? What happened?
I'm not going to discuss Prince Lateef Fagbemi as a person, because I choose not to. I'd rather discuss the office of the Attorney General, because it's an extraordinarily important institution in the public space. It's the only cabinet office created explicitly in the Constitution, so it is. It's that serious. Now, the fact of the matter is that the quality of the office has degenerated over the years. Now, in 1983, President Shagari decided to appoint Kehinde Shofola as Attorney General of the Federation. Kehinde Shofola declined initially. And in the end, after persistence from President Shagari, and he asked him why, President Shagari, why, and Shagari said, look, in his first tenure, the party dictated whom the cabinet could be. But that in his second tenure, he knows the party better, he knows the country better, and he wants a choice as to whom he wants to work with. And he had selected this, he had come to Kehinde Shofola because he wanted to work with Chief Shofola, senior advocate. So Chief Shofola then told him his conditions on which he would take the position, one of which was, as Attorney General, he did not want to take dictation on matters that were legal. And that if he felt that at any point that he was being dictated to on matters that were within the legal purview of the Attorney General, he would be at liberty to quit, to reconsider his position. And President Shagari told him that was perfectly agreeable. That was how he accepted the position. Of course, he only did the job for 3 months, and President Buhari overthrew the administration. But that's no longer possible. These days, people believe that being an Attorney General is a position you can take to advance your judicial career and your visibility. And the, Abubakar Malami in particular, in my view, was the nadir. He brought the office of Attorney General into disrepute. And, and some people will, of course, argue that the current incumbent in that position is a kind of an upgrade on Malami, broadly speaking. And so that's one of the reasons I don't necessarily want to discuss him. But the judgment of Peter Lifu, in this case that you refer to, is a scandal. It's an absolute corrupt scandal. Whoever was involved with it. You see, if you want to do these kinds of things, in the school in which I was brought up, you do them by the book. So that even people who are inclined to disagree with the outcome will respect the process and the reasoning and the professionalism. Now, Peter Lifu said he was reading and interpreting Section 225A of the Constitution, which grants INEC a power, a discretion, under certain circumstances, to exercise a power to deregister certain political parties. He converted that power to a statutory duty. Now, the distinction between a power and a duty is one that a student doing year one in law will recognize. You cannot transform a power into a duty. Okay? But the second thing is that Section 225A says that to be able to deregister a party, those have to be parties that have not won any seats in specified elections. The evidence before Peter Lifu was that the parties he was seeking to deregister had all won seats. ADC had this number of seats, this other party had that percentage. He then invented something, which is part of the reason why I posed the question, did he write the judgment? Because he then invented something, that Section 225A does not contemplate someone who, after winning the election, defects to a new party. That is nowhere in the Constitution. What the Constitution requires is what did the party win at the election, not did the people defect or not. That is nowhere in the Constitution. That's an invention. No judge who is conscious of their office would undertake that kind of invention. That is corrupt on the face of the record.
I'm sure it's something future leaders of this country might want to look at, because that office is exceptionally
Exceptionally important.
Exceptionally. That's interesting.